What's the specific intervention that we're talking about? Hello?
Richard Jakpa was under cross-examination by counsel for first accused.
Yes.
And then, as he spoke, he said things the Attorney General was unhappy about. Mm-hmm. So the Attorney General made a comment, which comment suggested that Richard was at the trial to sort of do the bidding of the first accused. That's what Richard took exception to, and began to reply him by saying that he has met him several times at odd places and so on. Questioning, should the Attorney General have made that intervention?
No, cross-examination is at large, and therefore, it cannot be limited as long as the question is relevant to the proceedings before the court. So if the Attorney General asks questions by way of the cross-examination...
No, Kweku Paintsil. It was not the Attorney General who was cross-examined. It's not time for the Attorney General here to cross-examine. The cross-examination was being done by counsel for the first accused, not the state.
The counsel for the first accused was cross-examining
the third accused.
Whoa. No, the Attorney General is part of the trial. And therefore, within the context that we are speaking, he has a right to object to any question or any answer which a party is given as part of the trial. And therefore, as a matter of law, the question or any cross-examination or any intervention was proper. At the end of the day, it's for the judge, as part of the summing up of the case, to determine the propriety of any question that is asked, whether of the party's own witness or somebody else's witnesses. But at the point that the Attorney General made an objection, he was entitled to raise any objection which the judge, of course, at the end of the day, has to rule upon. So I wouldn't find anything wrong for an intervention.
So let's get the issues in the clearer perspectives for those who don't appear to appreciate exactly what happened in the courtroom.
Yes.
The Attorney General did not raise an objection.
Yes.
Did not raise an objection to the cross-examination, but to the comments, the testimony of the witness when the first accused counsel was cross-examining him.
Yes, Adam.
Oh,
hello?
Yes, you're on.
Hello. At the end of the day, the trial was going on. Correct. And as you said, the question was being put by counsel to a witness. And whatever the witness says, the trial involves all the parties. So if the Attorney General has any reason to raise an objection, I don't know how we can call it. But if the Attorney General expressed his displeasure with the answer that the witness had given, that's as good as an objection. In other words, he wanted the court to caution itself either to exclude that particular evidence that was being led as whether relevant or irrelevant. So with due respect, it's not a particular name we give to the intervention. I would put it, properly speaking, as a form of objection that the Attorney General raised to the answer that was given by the witness. In other words, the idea was that the judge would act on his objection and properly exclude that evidence. That would be the only reason why the Attorney General will intervene in the manner that he did.
Right. So the Attorney General, being part of the trial, even though he's not the one cross-examining the witness at the time, was entitled to make an intervention by way of an objection to an answer that the witness was giving at the time, correct?
Quite naturally.
Thank you.
Naturally, yes, the answer is yes.
Yeah, you have explained. I just wanted you to confirm.
Yeah. And therefore,
Right.
There's no special time that will be given to the Attorney General to raise any issue which concerns the entire trial before one judge. So that's, in my honest view, the right and the proper way for the Attorney General to have intervened at the point that he did.
Right. Thank you. Hold it there for me. Do you confirm what Frank Davis has said as the practice that we are familiar with? That you are the lawyer, a witness is giving testimony, you do not have the opportunity of replying the witness. Your opportunity is when you take your turn to cross-examine, then you put that testimony through fire. Correct?
I agree with my learned senior Frank Davis, and I would like to add to that by saying that litigation essentially is tactical. Whether to ask a question, which, ask a question of a witness of something that he has said there and then, or subsequently. In this particular case, it has not even reached the time of the Attorney General. It has not reached, and therefore the trial was not over. And the reason why the Attorney General, indeed and in fact, with due respect, it is my personal view that in the context of the trial itself, that evidence, in my honest view, was irrelevant. It had no bearing whatsoever on the matter that was being tried. The fact that an incident transpired in the course of the suit, which a party knew but never put it in his witness statement or did not make an issue of it, but got angry during cross-examination on the basis of his anger or his response, says something which was not before the court, does not make it a relevant issue for the court at all. And therefore, even if the Attorney General decided in the scheme of things never even to ask a question on that issue, personally, I wouldn't know and I wouldn't see how that retort by the witness in the box was going to affect the outcome of the case one way or the other. Because I've never seen, with due respect, I've limited knowledge of all the factual evidence before the court. But I've never heard anywhere that the witness statement of Jakpa or any of them rely on a live meeting between him and the Attorney General. I don't know. But if that evidence was not before the court, the mere introduction of that evidence at the stage that he claimed the Attorney General was annoying him or whatever, I personally would not see how, at the end of it, if I summon up the case, you can introduce that to sway the judge or to persuade the judge or to make the judge believe that something that transpired out of the court has any influence on the outcome of the case.
You are not saying. You are not saying, and this is a point you have made over time in the week. You are not saying that the conduct of the courts, counsel, or parties, or witnesses, any misconduct that could impact on the fairness of the trial could result in a mistrial. You are not saying that cannot happen?
No, in the absence. You see, you can raise an issue of mistrial by a formal application where the entire evidence...
No, I mean when you said it's irrelevant, it does not impact on the case. It does impact on the case, correct?
So the exchange of that day, at the point that this incident took place, I wouldn't know how the judge can take that into consideration in the assessment of the evidence before the court, when that did not even form part of any party's case before the court.
All right.
I wouldn't know.
Okay. So now hold on. Now let's now move in this direction. Yeah.